Republic Act No. 386, also known as the Civil Code of the Philippines, is a general law that governs family and property relations in the Philippines. What does it specifically govern? To give you an overview, it consists of 4 books. First, Persons and Family Relations. Second, Property, Ownership and its Modifications. Third, the Modes of Acquiring Ownership. And fourth, Obligations and Contracts. The first book, Persons and Family Relations, include the following. First, civil personality, citizenship and domicile, domicile meaning your place of residence, marriage, legal separation, rights and obligations between husband and wife, property relations between husband and wife, the family, paternity and filiation, filiation, your relation or lineage. Maintenance, like alimony and child support, alimony is a financial support. Funerals, parental authority, care and education of children, use of surnames, absence. The absence here talks about the absentee, nawawalang tao. Emancipation and age of majority. Emancipation is being legally free and qualified for all acts of civil life. And civil register. Civil status of person shall be recorded in the civil register. The second book, Property, Ownership and its Modifications, includes the following. Classification of property, ownership, co-ownership, special properties, possession, usufruct. Usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance, unless the title constituting it or law otherwise provides. Easement and servitudes. Easement is a right to cross or otherwise use someone else's land or for a specified purpose. In here, you'll see easement of right-of-way, drainage of buildings, and other common problems we encounter. Nuisance and registry of property. The third book is the different modes of acquiring ownership. We have occupation. Occupation here is about ownership due to occupying or being occupied. Intellectual creation, donation, succession, that includes wills, heirs, inheritance, legacies, and others. And acquisitive prescription. By prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by the law. Fourth book, the Obligations and Contracts. We have obligations, contracts, natural obligation, estoppel. Estoppel is a judicial device in common law legal systems whereby a court may prevent or stop a person from making assertions or from going back on his or her own words. We have sales, barter or exchange, lease, partnership, agency, loan, deposit, aleatory contracts. An aleatory contract is a contract where an uncertain event determines the parties' rights and obligations. Compromises and arbitrations, guarantee, pledge, mortgage, and antichrisis. Antichrisis is a contract whereby a debtor pledges real property to a creditor. Extra contractual obligations, damages, concurrence and preference of credits. Now let's talk about human relations. Article 19, the first article under human relations, states that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. What we can get from here is the principle of abuse of rights, which concepts are first, a person must, in exercise of his legal right or duty, act in good faith. Second, he or she would be liable if instead acted in bad faith, with intent to prejudice or injuring another. When we say good faith, it refers to the state of mind which is manifested by the acts of the individual concerned. It consists of the intention to abstain from taking an unconscionable and unscrupulous advantage of another. Malice or bad faith, on the other hand, implies a conscious and intentional design to do a wrongful act for a dishonest purpose or moral obliquity. Another is damnum usque injuria. Not all damages or injury requires liability, especially if one is making use of his or her legal rights. For example, in a specific street, there stands John's Milk Tea. Someone established another food stand nearby named Patrick's Food Stall, causing the loss of customers in John's Milk Tea. But Patrick's Food Stall would not be liable for their loss of customers. We have Acts contra bonus mores. In Article 21, any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. If the person does not violate the law, it doesn't mean that he or she is not liable for damages to the person civilly wronged. We have unjust enrichment, and Article 22 states that every person who through an act of performance by another or any other means acquires or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. There is unjust enrichment when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. The principle of unjust enrichment requires two conditions. First is that the person is benefited without a valid basis or justification, and second, that such benefit is derived at the expense of another. For example, John went to a jewelry store to have both of his rings cleaned. Patrick, the staff in charge to do the jewelry cleaning, was able to clean one ring, but not the other one due to some mishaps happened in the store. In that, Patrick would be unjustly enriched if John paid the cleaning service of two rings, but only one was cleaned. In another situation, John would be unjustly enriched if Patrick cleaned both rings, but paid for the cleaning service of only one ring. Another article to consider is Article 26, states that every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. First one is prying into the privacy of another's residence. Second, meddling with or disturbing the private life or family relations of another. Ayan, folks. I know that the content of Philippine humor is being marites, but folks, wag nating isabuhay. Number 3, intriguing to cause another to be alienated from his friends. And lastly, vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defects, or other personal conditions. Another thing to consider is Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. You can pause this video if you want to read it. Now let's move to Book 4, Obligations and Contracts. What are obligations? From Article 1156, an obligation is a juridical necessity to give, to do, or not to do. It is the responsibility of a party to meet the terms of a contract or agreement. If not met, the legal system often provides recourse with the injured party, basically a lawsuit, but maaaring kasuhan. Now let's move on to the different kinds of obligations. Pure and conditional obligations. Pure obligation is that whose performance does not depend upon a future and uncertain event, or upon a past event unknown to the parties and is demandable at once. For example, John promised to give Patrick 13,000 pesos. So it does not depend on a future and uncertain event, and it is demandable at once. Bibigay lang yung pera. When we say conditional obligation, the happening or extinguishment of which depends upon the happening of a future and uncertain event. Firstly, we have this. If the obligation may not be enforced until uncertain event occurs, the condition is suspensive. For example, John will give Patrick his new laptop if Patrick won the speech contest. So the obligation may not be enforced until the event, the speech contest, occurs. Another is that if the obligation may be immediately enforced but will come to an end when the uncertain event occurs, the condition is resolutory. Here's the example. John will let Patrick use his new laptop until the speech contest. So the obligation is immediately enforced, but it will end when the uncertain event occurs. Next one is obligations with a period. Obligation whose fulfillment, a day certain has been fixed, shall be demandable only when the day comes. Example, John will give Patrick 700,000 pesos on September 13, 2025. Alternative obligations, wherein various prestations are due but the performance of one of them is sufficient as determined by the choice which, as a general rule, belongs to the debtor. For example, John borrowed 70,000 pesos cash from Patrick. It was agreed that John has the alternative to pay Patrick either in 70,000 pesos cash, a Samsung Galaxy S22, or Lenovo IdeaPad S145. Now with joint and solidary obligations. In a joint obligation, each obligor answers only for a part of the whole liability, and to each obligee belongs only a part of the correlative rights. Here's the example. John and Patrick are joint debtors of Patch to the amount of 1 million pesos. Patch can demand only 500,000 pesos from John and only 500,000 pesos from Patrick. In a solidary obligation, the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously for the performance of the obligation. Example, John and Patrick are solidary debtors of Patch to the amount of 1 million pesos. Patch can demand the whole 1 million pesos from John. John in turn, after paying Patch, can ask reimbursement from Patrick to the amount of 500,000 pesos. Next is divisible and indivisible obligations. An obligation is divisible when the object of the performance is susceptible of division. For example, John agreed to pay Patrick 2,000 pesos in 4 equal monthly installments. The obligation of John is divisible because it is capable of partial performance. Money is physically divisible. An obligation is indivisible when the object of the performance, because of its nature or because of the intent of the parties, is not susceptible of division. Example, John obliged himself to deliver to Patrick a specific car on September 13. This obligation is indivisible because it is not capable of partial performance. The car must be delivered at one time and as a whole. Obligations with a penal clause. The penalty fixed by the parties is a compensation or substitute for damages in case of breach. Example, John obliged himself to pay Patrick 10,000 pesos with a penalty of 1,000 pesos if he cannot comply on time. If John failed to comply as stated, Patrick can demand from John the principal of 10,000 pesos plus 1,000 pesos penalty. He cannot demand payment of interest plus damages because the penalty is the substitute for interest and damages unless otherwise stipulated. Now with extinguishment of obligations. Payment or performance. In Article 1232, payment means not only the delivery of money but also the performance in any other manner of an obligation. Example, if John is obligated to repair the computer of Patrick, payment is made by performing the service, the repair. Next is loss of the thing due. In Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. Example, John borrowed the car of Patrick. On the due date of the obligation, John told Patrick that the car was stolen and that he was not at fault. That is not enough to extinguish John's obligation. It is presumed that the loss was due to his fault. Hence, he is liable unless he proves the contrary. But in the situation where John's house was destroyed by a typhoon and the car was inside the house, John would not be liable. Condonation or remission of the debt. Article 1270, condonation or remission is essentially gratuitous and requires the acceptance of the obligor. It may be made expressly or impliedly. It is the gratuitous abandonment by the creditor of its right against the debtor. It is thus a form of donation. Now, confusion or merger of rights. Article 1275, the obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Let's see the example. Duke John owes Prince Patrick 800,000 pesos. Before Prince Patrick can collect, he died and the credit passes on to his heir, Prince Patch. Sometime in 2015, Prince Patch owed Duke John the amount of 800,000 pesos from Prince Patch's purchase of ceremonial tables. In satisfaction of his debt, Prince Patch assigns Duke John the credit he inherited from Prince Patrick. Now there is a merger of creditor and debtor in one person, and that is Prince Patch. Compensation. In Article 1278, compensation shall take place when two persons in their own right are creditors and debtors of each other. For example, John owes Patrick 20 million. Patrick on another occasion owed John 25 million. Patrick is liable to John with 5 million, so they are both the creditors and debtors of each other. Lastly, we have novation. Novation is the substitution of a new contract in place of an old one. In Article 1291, obligations may be modified by first, changing their object or principal conditions. Example, John agreed to deliver to Patrick a refrigerator. Later, they entered into another contract whereby instead of John delivering a refrigerator, he would deliver 7 rice cookers. The obligation to deliver a refrigerator is extinguished by the obligation to deliver the 7 rice cookers. The change may be involved the principal terms of the obligation. Next, substituting the person of the debtor, and number 3, subrogating a third person in the rights of the creditor. Example, if after the constitution of the obligation, both parties agreed that J will substitute for John, or in other situation, Patch will be subrogated in the rights of Patrick. That's number 3. There is a personal novation. In this case, J becomes the new debtor, or in other, Patch the new creditor as case may be.
Chapter 1 General Provision. Article 37. Juridical capacity, which is the fitness to be the subject of legal relation, is inherent in every natural person and is lost only through death. It is inherent in every natural person. Capacity to act is the power to do acts with legal effect. It may be acquired and it may also be lost. It is acquired upon the attainment of the age of majority. A person is a physical or legal being susceptible to rights and obligation or being the subject of legal relation. A right is the power which a person has to demand from another, a power to do or not to do, or to demand something. On the other hand, an obligation is the juridical necessity to give, to do, or not to do. From the viewpoint of another, shouldering an obligation, the creditor or obligee right is the reason why the obligation has to be performed, paid, fulfilled, or accomplished. Article 38. Minority, insanity, or imbecility, the state of being a deaf, mute, prodigality, and civil interdiction are mere restriction on capacity to act. It means that do not exempt the incapacitated person from certain obligation, as when the latter arise from his acts or from property relation, such as easements. Article 39. The following circumstances, among others, modify or limit capacity to act: age, insanity, imbecility, the state of being a deaf, mute, penalty, prodigality, family relation, alienage, absence, insolvency, and trusteeship. The consequences of these circumstances are governed in this code, the rules of court, and in special laws. Capacity to act is not limited on account of religious belief or political opinion. Capacity to act is the quality or validity that is granted to people to carry out any type of legal action that entails rights and obligations. This occurs because the person is considered to have the ability to regulate their interests through their actions. The limitation of the capacity to act of the people usually come through the minority of age, by a judicial limitation, or by the marital status in which they are. Chapter 2. Essential Requisites of Contract. Section 1. Consent. According to Article 1319, consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. It is similar to a contract. It may be oral or written, that a patient has signed a consent form regardless of how explicit or detailed it may be. The offer must be certain and the acceptance absolute. A qualified acceptance constitutes a counter-offer. Acceptance made by letter or telegram does not bind the offerer except from the time it came to his knowledge. The contract in such a case is presumed to have been entered into the place where the offer was made. The consent form is merely documentary evidence which can be rebutted in a court of law. According to Article 1320, an acceptance may be expressed or implied. It means that an expressed acceptance in the form of a promise to pay a certain amount or to do something may be oral or written. An implied acceptance is one that is inferred from act or conduct. For example, Ms. Garcia promised to pay Ms. Hebres 1,000 pesos for repairing his aircon and making it run again. Here, only Ms. Garcia has promised to do something. By doing the requested act, if Ms. Hebres accepts the offer by promising to do the requested act, there are promises on both sides. It has been held that where a person accepts the service of another, whether solicited or not, he has the obligation to pay the reasonable value of the service thus rendered upon the implied contract of lease of service, unless it is shown that the service was rendered without any expectation that she would pay for the same. According to Article 1321, the person making the offer may fix the time, place, and manner of acceptance, all of which must be complied with. The acceptance must be made known to the offeror before the lapse of the fixed period. If the acceptance was made after the fixed period, it is not a legal acceptance anymore. What happens then is that it becomes an offer made by the previous offeree, which may or may not be accepted by the original offeror, which becomes the offeree. In terms of the manner of acceptance, the offeror may require that the acceptance be done by letter, personal communication, or through a representative. Acceptance which was not made in the manner fixed by the offeror constitute a counterproposal which extinguish the offer and may not be accepted by the original offeror. According to Article 1322, an offer made through an agent is accepted from the time acceptance is communicated to him. This article means that when an offer appoints a third person as his agent to represent him, the offer by the agent, when accepted by the offeree, is deemed accepted not from the knowledge of the acceptance by the offerer or principal, but from the moment the agent has received the communication of acceptance. The meeting of the minds is thus established. The agent must be authorized by the offeror. An example of an agent is an attorney in fact, authorized through a power of attorney. If the intermediary is not authorized, the offer is not binding to the offeror. The offeree may also act through an authorized agent. According to Article 1347, all things which are not outside the commerce of men, including future things, may be the object of a contract. It means that all rights which are not intransmissible may also be the object of contracts. No contract may be entered into upon future inheritance except in cases expressly authorized by law. All services which are not contrary to law, morals, good customs, public order, or public policy may likewise be the object of a contract. According to Article 1348, impossible things or service cannot be the object of contracts. If the thing or service is impossible, there is no contract. Can there be any claim for damage against the debtor if the creditor incurred actual damage? It depends. If the both parties are fully aware of the impossibility of the thing or service, there is no liability for damage because both the debtor and creditor are considered in bad faith. If the debtor knew of the impossibility or could have known it by exercising ordinary diligence, he is liable for damage because he is negligent. But if the debtor is ignorant of the impossibility and his ignorance is justifiable or unavoidable, he cannot be held liable for the damage suffered by the creditor. According to Article 1349, the object of every contract must be determined as to its kind. It means that the fact that the quantity is not determined shall not be the obstacle to the existence of the contract, provided it is possible to determine the same without the need of a new contract between the parties. Section 3. Cause of Contracts. According to Article 1351, the particular motives of the parties in entering into a contract are different from the cause thereof. The cause of a contract is the objective and juridical reason for the establishment of a contract and is always the same, while motive is the psychological or personal purpose of a party in getting the object and differs with each person. Each party may have his own personal reason or motives in entering into a contract. Motive or even with illegal motives does not affect the validity of the contract. If the motive predetermines the purpose of the contract, motive may be regarded as cause. According to Article 1352, contracts without cause or with unlawful cause produce no effect. A contract is null and void if there is no cause or consideration. Cause of contract is the purpose of the contract. It is the essential reason which moves the parties to enter into the contract. Illegality of cause arises when the same is contrary to law, morals, public order, good custom, or public policy. It is produced for the purpose of preventing a prosecution for a crime. According to Article 1354, although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the debtor proves the contrary. It means that unless the contrary is proved, a contract is presumed to have a good sufficient consideration. In the event that the contract does not state its cause, it must be presumed that the cause exists and is lawful. This presumption, though, is rebutable if the debtor can prove otherwise. The existence of the cause or its legality can be questioned. Example, Pedro executed a promissory note due to a debt incurred in a local casino in town. If one, the obliged, is unable to gain proof that Pedro wasted the money borrowed to him, so the cause is valid. Chapter 3. Form of Contracts. According to Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. It means that contracts are binding upon the contracting parties in whatever form they may have been entered, as long as all the essential requisites for their validity are present. When the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the party stated in the following article cannot be exercised. According to Article 1357, if the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. It means that this right may be exercised simultaneously with the action upon the contract. When form is required by law for its convenience only and the contract it is not that form, contracting parties may compel each other to observe that form. Once the contract is required by the law, but if it is not essential for validity of the contract, then this art cannot be made.
Let's talk about Contracts Chapter 5, 6, 7, 8, and 9. For Chapter 5, Interpretation of Contracts. What is interpretation of contracts? It involves an ascertainment of the meaning of the words and provisions of a contract. From Article 1370, if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. Once the contract is clear, there's no need for it to interpret. You'll just have to interpret when the contract is not clear. From Article 1372, however general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. An example of it, Debbie sold to Jed her house, including all the furniture, but there's one furniture that Debbie is not the owner and it is owned by her relatives, her aunt. They can only get all the furniture owned by Debbie. From Article 1373, if some stipulation of any contract should admit of several meanings, it shall be understood as bearing that import which is most adequate to render it effectual. When an agreement is susceptible of several meanings, one of which would render it effectual, it should be given that interpretation. Thus, if one interpretation makes a contract valid and other makes it illegal, the former interpretation is one which is warranted by the rules of Article 1373. Next, Chapter 6, Rescissible Contracts. What is Rescissible Contracts? Rescissible contract is one that was entered into legally by the contracting parties but has resulted in economic damage to one of the parties or an outside party. From Article 1380, contracts validly agreed upon may be rescinded in the cases established by law. Granted by law to the contracting parties and even to third persons to obtain reparation or damages caused to them by a contract, even if the contract is valid, by means of restoration of the things to their condition to the perfection of the contract. From Article 1381, the following contracts are rescissible. Those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than one-fourth of the value of the things which are the object thereof. Those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number. Those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. All other contracts specially declared by law to be subject to rescission. From Article 1382, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were effected are also rescissible. If one party is unable to pay their debts, the injured party has the right to rescind the contract. Under Article 1382, rescission is only allowed to extent that is necessary to compensate for damages. The other party should return the items that were the subject of the contract along with the interest. Next, Chapter 7, Voidable Contracts. What is voidable contracts? A contract that is valid but that can be declared invalid at the request of one of the parties because of a defect or illegality in making it. From Article 1390, the following contracts are voidable or annullable even though there may have been no damage to the contracting parties. Those where one of the parties is incapable of giving consent to a contract. Those where the consent is vitiated by mistake, violence, intimidation, under influence, or fraud. From Article 1391, the action for annulment shall be brought within 4 years. In cases of intimidation, violence, or under influence from the time the defect of the consent ceases. In case of mistake or fraud, from the time of the discovery of the same. And when the action refers to contracts entered into by minors or other incapacitated persons, from the time the guardianship ceases. From Article 1392, ratification extinguishes the action to annul a voidable contract. And what is the meaning of ratification? The action of signing or giving formal consent to a treaty, contract, or agreement, making it officially valid. Next is Chapter 8, Unenforceable Contracts. What is unenforceable contracts? Unenforceable contracts is one that is valid but which the court will not enforce because of some defects such as non-disclosure, an extraordinary event, or other legislation. From Article 1406, when a contract is enforceable under the statutes of frauds and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. The contract is enforceable in this case, but the paper could not be enforced because it was not notarized. In that situation, Article 1357, which empowers one party to launch an action to compel the other to respond with the contract's required form. From Article 1407, in a contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian. As the case may be, one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardians, as the case may be of both contracting parties, the contract shall be validated from the inception. An incapable individual cannot ratify their own consent to a contract because they are unable to give legal consent. As a result, only the guardians have the authority to validate the incapacitated person's defective consent. For Article 1408, unenforceable contracts cannot be assailed by third persons. And next, Chapter 9, Void and Inexistent Contracts. What is void and inexistent contracts? Void contract is not actually a contract. A void contracts cannot be enforced by law. Inexistent contracts refer to agreements which lack one or some or all of the elements, the consent, object, and cause, or did not comply with the formalities which are essential for the existence of a contract. From Article 1409, the following contracts are inexistent and void from the beginning. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. Next, those which are absolutely simulated or fictitious. And those whose cause or object did not exist at the time of the transaction. And also those whose object is outside the commerce of men. And those which contemplate an impossible service. And those where the intention of the parties relative to the principal object of the contract cannot be ascertained. And last, those expressly prohibited or declared void by law. These contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. From Article 1411, when the nullity proceeds from the illegality of the cause or object of the contract, and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. From Article 1415, where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. And next, for Article 1421, the defense of illegality of contract is not available to third persons whose interests are not directly affected. And last, from Article 1422, a contract which is the direct result of a previous illegal contract is also void and inexistent. And that's all for Title 2 Contracts Chapter 5, 6, 7, 8, and 9.
Title 6, Sales. Chapter 1, Nature and Form of the Contract. Article 1458. By the contract of sale of one of the contracting parties obligates himself to transfer the ownership and to deliver the terminate thing, and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. Contract of sale is a contract whereby one of the contracting parties, which is the seller, obligates himself to transfer the ownership and to deliver a determinate thing, and the other party, who is the buyer, obligates himself to pay a sum of money or its equivalent.
Vendor. What are the obligations of the vendors? 2. The ownership of determined things. Ownership of the things sold shall be transferred to the vendee upon the actual or constructive delivery. To deliver the things. To warrant against eviction and against hidden defect. So, syempre, as a buyer, sinicheck natin yung possible warranty ng isang bagay na yon. Kung kailan natin pwedeng gamitin and kailan natin or kailan to ma-expire. To take care of the things pending delivery with proper diligence. So, syempre, as a pending delivery, dapat tinitake care natin yon and dapat nasa tamang kalagayan yung bagay na yon. To pay the expenses of deeds of sales unless there is stipulation of contrary. Syempre po, yung bahay, binenta. So, pag binenta mo yung bahay, possible na yung paglipat ng pangalan dun sa buyer, may possible na expenses doon. So, yun po yung tinatawag na expenses doon. Pero yun po is depende pa rin kung ano yung napagkasunduan ng both party. What is delivery? Delivery is referred to the concurrent transfer to things which are possession and ownership. Delivery has described as composite act, the things which both parties must join in mind of both parties concur. What are the kinds of delivery? Actual delivery refers to the thing sold occurs when it is placed under the control and possession of the vendee. Legal or constructive delivery refers to an act amounting to a transfer of title operation of law when actual transfer is impossible. What are the kinds of constructive or legal delivery? First, execution of public instrument of documents. Ito yung mga deeds of sales from the word deeds po. Ito yung mga may documents katulad na lang ng bahay, lupa, sasakyan, etc. Second, symbolical tradition or traditio symbolica. Ito naman yung mga hindi na-deliver in actuality, katulad na lang ng apartment. Siyempre, ang mangyayari doon, ibibigay mo na lang yung susi ng apartment. Traditio brevumano. Yung ownership is changed from rental to possession as an owner. There is no delivery happen since sa kanya na yung bagay na yon. Traditio constitutum possessorium. Example po nito is, ikaw yung may-ari ng bahay, pero yung bahay na yon is nabenta na. Pero, ikaw pa rin yung nakatira doon. Pero, not as an owner. Ikaw na yung lease ng bahay na yon. Quasi-delivery or quasi-traditio. Delivery of rights, credit, and incorporeal property. Implied warranties of seller. Warranty against eviction. The judgment is based on the right prior to the sale or an act imputable to the vendor. Warranty against hidden effects of the property. It must exist at the time of the sale. Warranty as to fitness or merchantability. Fit for ordinary purposes or which such goods are used. Chapter 5, Obligation of the Vendee. Article 1582, Principal Obligation of the buyer or vendee to accept delivery to pay the price at the time stipulated in the contract. Kung saan at kailan i-deliver yung bagay na yun, dun mo rin dapat bayaran. The buyer of good is not bound to accept delivery thereof by installments. The buyer has a right to examine the goods before accepting them. Exception, there is stipulation otherwise. In case of collect on delivery, when there is an agreement or usage of trade permitting such as examination, so may exception to the exception. Types of acceptance. First, express acceptance. Ito yung pag-accept ni buyer. Second, implied acceptance. Pinapakita niya as if siya yung may-ari, pero implied acceptance. Also, nasa kanya lang yung good, hindi niya naman sinasabi kay seller na naibalik niya na. As if sa mata ni seller o sa mata ng batas, inaccept niya na or inaccept na ni buyer kahit wala pang express of acceptance. Acceptance of goods by buyer shall not discharge the seller from liability and damage or other legal remedy for breach of any promise or warranty in the contract of sales. Effect of the buyer justifiable refusal to accept delivery. The buyer has no obligation to return the goods to the seller. It is sufficient that the buyer notifies the seller that he refused to accept the goods, and if the buyer voluntarily constitute himself as depositary of goods, he shall be liable as such. Effect of buyer unjustifiable refusal to accept delivery. The title there is rather to passes to the buyer from the moment they are placed at his disposal. Article 1589. The vendee shall owe interest for the period between delivery of the things and the payment of the price in the following three cases. Should it have been so stipulated, magiging liable si vendee for payment and interest between the things sold and payment kung napag-usapan. Should the things sold and delivered produce fruits or income, syempre magiging liable yung fruits na sinasabi doon for the interest. Should he be in default from the time of judicial and extrajudicial demand for the payment of the price. Chapter 6. Action of breach of contract of sale of loan. Article 1594. Action of breach of the contract of sale of loan shall be governed particularly by the provision of this chapter, and as a matter that specifically provide for herein by the other applicable provision of this title. Once party failure to fulfill any contractual obligation is known as a breach of contract. A breach of contract is when one party breaks the term of an agreement between two or more parties. This includes when the obligation that is stated the contract is not completely on time. Article 1595. Where, under the contract of sale, the ownership of the good has passed through the buyer and wrongfully neglect or refuse to pay the goods according to term of the contract of sale, the seller will maintain an action against him for the price of the goods. Example, S sold his laptop to B. Subsequently, S delivered the said laptop to B. However, B thereafter wrongfully neglect or refused to pay the laptop. In this case, S may sue or file an action against B for the price of the goods. Remedy of the buyer in case of breach of warranty by the seller. Accept or keep the goods and set up against the seller the breach of warranty by way of recruitment in diminution or extinction of the price. Accept or keep the goods and maintain an action against the seller for the damage for the breach of warranty. Refuse to accept the goods and maintain an action against the seller for the damage for the breach of warranty. Rescind the contract of sale and refuse to receive the good, or if the good have already been received, return them or offer to return them to the seller and recover the price or any part thereof which has been paid. Chapter 7. Extinguishment of Sales. Article 1600, sales are extinguishment by the same causes as all other obligations by those stated in the preceding article of the title and by convention or legal redemption.
Conventional redemption. It is the right which the vendor reserved to himself to recover the thing sold, with the obligation to reimburse to the vendee the price of the sale, the expense of the contract, and any other legitimate payment made by reasons of the sale, and the usual and necessary expenses incurred for the account of the thing sold. The right can be exercised on the following.
First, if no stipulation within 4 years. Kung si Ana ay nagbenta ng lupa kay Jose noong March 17, 2018, pwede niya ulit bilhin yon bago mag 4 years, which is March 17, 2022. Number 2, if there is stipulation, the stipulation will control but not exceed 10 years. Over and above the 10 years period is void. Ibinenta ni Ana ang kanyang lupa noong Enero 20, 2015 sa halagang 150k. Maaari niya ulit bilhin to basta wag lang lalagpas ng 10 years. If there is a prohibitive period, exclude the prohibitive period and begin counting the 4 years period. If the prohibitive period and the 4 years period exceed 10 years, over and above, the 10 years period is void. For example, noong June 1, nagbenta si Ana ng lupa kay Jose na may tamang repurchase, but such right cannot be exercised within 3 years. The right can be exercised from June 2 to June 1 because there is no time agreement. Exclude first the 3 years period, then begin counting the 4 years period. If the prohibited period and the 4 years period exceed 10 years, over and above, the 10 years period is void. Article 1603. In case of doubt, the contract purporting to be a sale with right to purchase shall construed as equitable mortgage. Legal redemption. It is the right to be subrogate upon the same term and condition stipulated in the contract in the place of one who occurs a things by purchase or lesion in payment or by any other transaction whereby ownership is transmitted by onerous title. Legal redemption. Within 30 days from written notice by the vendor. Legal preemption. Within 30 days from written notice by prospective vendor. The deed of sale shall not be recorded in the registry of property unless accompanied by the affidavit of the vendor that she or he has given written notice thereof to all possible redemption. So dito lumalabas na napaka-importante ng notice. Para ma-exercise mo yung legal redemption, kailangan may notice ka. Kapag wala kang maipakita ng notice na yon, and hindi ka naka-execute ng affidavit, yung deed of sale hindi ma-record sa registry of property. Article 1620. A co-owner of the thing may exercise the right of the redemption in case of the share of all the other co-owner or of any of them are sold to a third person. If the price of the allegation is grossly expressive, the redemptioner shall pay only a reasonable one. So kung yung share ng any of co-owner ay binenta sa third person, yung another co-owner may exercise ng right of redemption para palabasin yung third person para mawala sa co-owner. Dito sa article na to, mini-minimize ng batas yung co-ownership. Since the share of the co-owner must have been sold to the third person and not to another co-owner. Chapter 8. Assignment of Credit and Other Incorporeal Rights. Article 1624, an assignment of creditor in other incorporeal rights shall be perfect in accordance with the provision of Article 1475. Assignment of credit in right is the process of transferring gratuitously or onerously the right of the assigned or the assignee who would be allowed to proceed against the debtor. Incorporeal rights is a right to intangible rather than tangible property. Kung si Ana ay may utang kay Jose na 5,000, itinalaga ni Jose ang kanyang karapatan sa kredito kay Maria para sa isang pagsaalang-alang na may paunawa kay Ana. Si Jose ang nagtalaga, si Maria ang nakatalaga, at si Ana ay kailangang magbayad kay Maria at hindi na kay Jose. Article 1625, an assignment or credit, rights or action shall produce no effect as against third person, unless it appears in the public instrument or the instrument is recorded in the registry of property in case the assignment involves real property. Requirements to produce effect as against third person. If the personal property is involved, a public instrument is required to make the assignment effective against the third person. Second one, if real property is involved, the instrument is recorded in the registry of property to make the assignment effective against third person. Article 1626. The debtor who, before having knowledge of the assignment, pays his creditor shall release from the obligation. Ana owes Jose, evidenced by promissory note. Subsequently, Jose against his credit to May without the knowledge of Ana. Thereafter, Ana pays Jose. Question: is the obligation of Ana extinguished? The answer is yes, because Ana pays Jose before having knowledge of the assignment. The payment to Jose is valid.
Good day everyone. So today we will tackle about common carrier. So first, what is common carrier? A common carrier is a person or a commercial enterprise that transports passengers or goods for a fee and establish that their service is open to the general public. Typical examples of common carriers include a ship owner, railroad, airline, taxi, and etc. So let's proceed to the subsection 1, General Provisions. So, Article 1732, common carriers are person, corporation, firms, or association engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation, offering their service to the public. Next is the Article 1733, common carriers from the nature of their business and for other reasons of public policy are bound to observe extraordinary diligence and the vigilance over the goods and for the safety of the passengers transported by them, according to all the circumstances of each case. So, Article 1733, everywhere, carriers incur a measure of liability to the safety of the goods. And in common law countries, carriers are liable for any damage or the loss of the goods that are in their position as carrier, unless they prove that damage or loss is attributable to certain expected costs. Next is subsection 2, Vigilance over goods. So, in Article 1734, common carriers are responsible for the goods, responsible for the loss, destruction, or deterioration of the goods unless the same is due to any of the following causes only. Number 1, flood, storm, earthquake, lightning, or other natural disaster or calamity. 2, act of public enemy in war, whether international or civil. 3. Act of omission of the shipper or owner of the goods. 4. The character of the goods or defect in the packing of the container. And last, order or act of complement public authority. So in Article 1734, it should be noted that this cause should be the proximate and only cause of the loss, destruction, or deterioration of goods. And let's proceed to the subsection 3, Safety of Passengers. Article 1755, a common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of very cautious person with a due regard for all circumstances. By contract of carriage, the carrier assumes the express obligation to transport the passengers to his destination safely and observe extraordinary diligence with a due regard for all circumstances, and any injury that might be suffered by passengers is right away attributable to the fault or negligence of the carrier. In Article 1756, in case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observed extraordinary diligence as prescribed in Articles 1733 and 1755. So in 1756, a public utility once it stops is in effect making a continuous offer to the bus riders, even the moving as long as it is still slow in motion. Stepping and standing on the platform of the bus is already considered as a passenger and is entitled all the rights and protection pertaining, such as contractual relations, in port, actual damage in base or net clearing. But the law provided that the passenger is carried gratuitously or free. Stipulations may limit the common carrier liability, but only for negligence and not for willful act or gross negligence. In Article 1757, the responsibility of a common carrier for the safety of passengers as required in Article 1733 and 1755 cannot be dispensed with or lessened by stipulation by the posting of notice by statement or tickets or otherwise. In 1755, if we can still remember, for the vigilance of the goods, the liability of the common carrier starts when it unconditionally obtains possession over the goods and ends when the shipper receives a goods or when the consigning authorized person has opportunity to remove or dispose of the goods. So in Article 1758, when the passenger is carried gratuitously, is stipulation limiting the common carrier's liability for negligence is valid, but not for willful act or gross negligence. The reduction of fare does not justify a limitation of the common carrier liability. Article 1759, common carriers are liable for the death of or injuries to the passengers through the negligence or willful act of a former's employees, although such employees may have acted beyond the scope of the authority or in violation of the order of the common carrier. This liability of the common carrier does not cease upon proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. In 1759, where it hires its own employees or avail itself of the service of an outsider or an independent firm to undertake the task, the common carrier is not relieved of its responsibility under the contract of carriage. Prudence can be liable for tort under Article 21, 76 and related provision and conjunction with Article 21, 80 as the Civil Code. Tort may arise even under a contract where the tort quasi-dialect liability is which breaches the contract. Example of this is if employer's liability is negligence or fault on the part of the employee, employer can be made liable on the basis of the presumption juris tantum that the employer failed to exercise diligent Patrick families in the selection and supervision of its employees. So let's proceed to the article. Article 1760, the common carrier responsibility prescribed in the preceding article cannot be eliminated or limited by stipulation by the posting of notice, by statement on the tickets or otherwise. Article 1761, the passengers must observe diligence of a good father or family to avoid injuries to himself. So, in Article 1761 and 62, concludes that the passenger should also observe caution. While the law requires the common carrier to observe extraordinary diligence, the passenger must do his part in observing diligence to avoid injury himself. In Article 1761 Civil Code of the Philippines, for example, the passenger should not intentionally extend his arm outside of the jeepney, stand on the door of a bus, hang outside the jeepney otherwise known as cabin or ride, or the roof of a public utility vehicle. 1762, the contributory negligence of the passenger does not bar recovery of damage of his death or injuries if the approximate cause thereof is the negligence of the common carrier, but amount of damages shall be equitably reduced. So in Article 1763, a common carrier is responsible for injuries suffered by a passenger on account of the willful act or negligence of other passengers or of strangers. If the common carrier employee, through the exercise of the diligence of a good father of a family, could have prevent or stopped the act or omission. So example for Article 1763 is George, who was a paying passenger on a Baliwag bus. He has thrown off by the bus, driven in a careless and negligent manner by Leonardo Cruz, authorized bus driver. His parents, spouses Soterio Calipan Jr. and Zenaida Lopez, shouldered his confinement at the hospital. So they filed against Baliwag, who filed a third-party complaint against Fortune Insurance. Contract is that Baliwag and George, who was already of legal age despite being a student and dependent on his parents for support. The release of claims George signed during the pendency of the case is valid.